Welcome to Houston Real Estate Radio. I'm your host, Shannon Register, and every week we bring you news and information you can use on your next real estate transaction. Today we're talking about townhouses and condos and some of the issues that people run into when owning a condo, things to be aware of. The phone number to call in if you've got a real estate question is 844-788-9444. We welcome your questions, like to answer them right here on the air, 844-788-9444. And of course, if you miss any of today's segment, you can go back and watch it at HoustonRealEstateRadio.com because we video record every segment. So this segment, we're talking with an attorney, a real estate attorney, and earlier you heard from Dory Gordon and her situation with owning a condo, and she's owned lots of condos, not had any problems with a lot of them, and then now she has run into a problem. So we're trying to talk through kind of what the problems are that you can have and how to resolve them, because if you're out there as a consumer and you're purchasing a condo and kind of stuck at a dead end with your association, we want you to know where to go for help. So James Wiedemer is here in the studio. He's authored several books. He and his dad both have authored several books on real estate. He was licensed as an attorney back in 1979. So he has been helping people with real estate problems, both commercial and residential, for a very, very long time. He's also a real estate trainer as well. So I want to welcome you to the show, first of all, because this is your first time on the show. So welcome.
Good morning, Shannon. Yes.
So we're excited to have you on because I know you're familiar with Dory's situation. So we want to talk about that and just really in general, we want to help people because there are people who are buying condos as foreclosures, and we want to make sure they know the pitfalls they could fall into. So let's start with Dory's situation, which we talked about a little bit earlier in the show. And, I guess the biggest question is, how can this happen? How can you run into these sorts of problems with your association?
Well, what happens is sometimes properties are simply not maintained, or from long ago, particularly back in the bad old 80s, you can have even some leftover problems today. Somebody perhaps was permitted to do something that really isn't consistent with the proper construction techniques, but they had to keep people in the condo back then, and so they let them get away with it. Mm-hmm. And at a subsequent time, maybe that needs to be disclosed, and that could be a problem. It could still be a sleeper of a problem. So old condos sometimes have those problems. Anything that dates from the 80s that had a lot of rehab work back in that period could still have difficulties. And moving forward, and if we get down market conditions, we're not quite there yet, but if we do get some down market because of these low oil prices, condos can run into a number of problems, because if you start to lose owners in a condo complex, you have fewer people to pay the dues. As you have fewer people to pay the dues, it is ultimately condo owner democracy, and they'll vote in a board and they'll say, gosh, I got to have a break or breather from these high dues. And so what they'll begin doing are maybe deferring maintenance, not doing as much, or regularly scheduled maintenance gets put off, and they're hoping it all turns around and gets better soon. We know that thing, and as long as it does, it works. But if it doesn't, then we've got a continuing problem. And so that's one source of problems. The other source of problems is sometimes when you're dealing with people in a down market situation, they're a little desperate. They want to get that thing sold. Right. And I hate to say, but it's more of a temptation to, the frauds and so forth. Let's say they know it's going to take an expensive repair. What they may do is they're looking at, gosh, at this price and with what I still owe on my loan, if I throw in this repair, I'm under. I can't pay off the loan, or I don't make any money, and they're a little desperate, and that leads to trouble. So the key, I think, to this is prevention. And keep your eyes open. I used to teach my classes, and I would tell my students, if you ever buy a house without an inspection or a condo without an inspection, I will break your kneecaps. And I'm serious. You must get an inspection. New construction, Jim, we don't need it. No, yep, you do need it, even if it's new construction. Relatively new condo, or I've walked through it, it looks good. You need expert eyes. There's stuff back there, and you need expert eyes. Even that is not always sufficient to find everything.
Like in Dory's case, she did have an inspection, and they didn't find any issue with it. So let's go to the condo association. Okay, we know on a foreclosure, the seller does not have to do a normal seller's disclosure. It's not required.
That's correct. Under 5.08 of the Texas Property Code, normally sellers must provide you with this fairly detailed multi-page seller's disclosure. It's required on all home sales. But If it's a foreclosure resale by a financial institution, they do not have to provide that certificate. However, they may still have to disclose if it's a simple resale, if it's not direct out of the actual legal foreclosure, but if it's a simple resale, if they know something, they need to disclose it. There's a good case on that, Prudential out of Austin, that said it didn't hold in so many words, but basically it raises the issue that if a lender did know, they could be liable, but if they don't know, which is often the case,
most
then they
lenders
don't have
are not
to
going
disclose.
to know. They're never going to see the property. They're not going to have a renter in there. They're not going to know. But the condo association may have known. So let's go there. What if the condo association knew you have a resale certificate on a condo that has to be presented to the buyer?
That's correct. In addition to a 5.08 seller's disclosure form on a condo resale, the law also requires in Texas that the association prepare a resale certificate. And on the standard TREC version of that resale certificate, letter I says the association's board checkbox has actual knowledge, checkbox has no actual knowledge of conditions on the property in violation of the restrictions applying or the bylaws of the association. And it says if there are known violations are.
Right.
So if they know something, they should disclose it.
So Dory would have gotten one of those. So I guess the question is...
I hope so. That's the first thing you check for. Did she get one or didn't she get one?
Right. And assuming she got one, now the question is, did they disclose or did they not disclose it?
Very key question. If they did disclose it, then it makes it a lot harder for Dory to sue for failure to disclose a material fact, or even if there was technically a false statement, if she knows about the falsity, that's a problem.
Mm-hmm. And if they did not disclose,
then they could have liability. The typical kind of RX pack for that legally would be things like fraud in real estate, 27.01 Business and Commerce Code, false statements or false promises. They're intended to be relied on in the sale of real estate. There can be liability for that. Fraud in real estate is common law. False statements known to be false at the time they're made, intended to be relied on, were relied on, and damage. You've got fraud and DTPA, failure to disclose material fact which is known at the time of the transaction. If such failure to disclose was intended to induce the consumer to enter into a transaction they would not otherwise have entered.
You got a lot memorized.
Yeah, I know. That one comes up so often. And a lot of people say, well, can't I just sell it as is? And as is does not necessarily protect you from a liability under DTPA. In fact, 1742 specifically says that waivers of the DTPA rights are unenforceable and void. So you can actually sign a statement. I buy it as is, and I will never sue, and I waive all rights to sue under deceptive trade practice. That's not sufficient. It is now, because of the tort reform laws that were passed during Governor Bush's term, it's possible to do a waiver, but you have to have an attorney sign off on it. And since that's generally not going to happen, and it has to have very special wording and so forth, and nobody ever does that. But an as-is, a lot of people mistake that, is not sufficient to protect you. So
if a property owner, let's say we've got a property owner out there and they bought a condo and they're having a problem, and it's an exterior repair, which we know the condo association is responsible for.
Yes.
And the condo association, like in Dory's case, is not making the repair. What should you do?
Well, I hate to say, but the first and easiest thing is to make sure it's not just the management company, but go to the board meeting if you can and explain the situation, or you may even have to bring an attorney. That would probably be the next step, would be to write letters and say, hey, you've got this issue and we need it corrected. And
because whether they disclosed it or not on that form, they still are responsible for the exterior of the property, regardless of... Well,
that could be more of an issue, because it depends a little bit on how the condo declaration is set up. But sometimes if somebody violates the restrictions deliberately or knows they have, then the condo association will try to beg off on the liability. Dory's situation is a little more complicated, though, because she wasn't the one who violated. It's the old owner. Yes.
Now, if an old owner did this violation, disturbed the roof, and the condo association's not approving that work that was previously done, can they say, we're just not going to fix your unit's roof, but can they just take out one unit and say they're not going to cover it?
I think they're kind of shooting themselves in the foot with that approach, because they're in effect admitting we do have the responsibility to do that, but just not for you. I think that would not work to their advantage defense side to say that.
When it went into foreclosure, if the condo association knew that there was any issue with it, filling out this disclosure would have protected the condo association. That would have been the right thing to do,
well,
right?
Yes, that would help protect the condo association, definitely.
Okay. All right. And what about all the mold and water damage that Dory's experiencing inside of her condo? Let's say she wins this and the condo association goes and fixes all of this. Are they going to be fixing the interior as well, or is she still going to be responsible for the interior, even though the exterior was caused by the problems they wouldn't fix?
I think if it's caused by, I've had that situation before, actually, with roof leaks, and I've taken the position that the consequential damage of their own negligence or failure to undertake the duties they have is something they have to pay for, and I think you can probably make that stick.
Okay. All right. Very good. And last question, totally separate. It's about lighting issues. If the condo association has been made aware that, lights are not working properly and they don't repair them and there are issues, theft, attacks, anything like that, is there any liability there on them?
Yeah, there may be. It's a very interesting area. For a while, that was a red hot area for litigation. The only problem is the legislature kind of came at that from an interesting direction, is they took out the punitive damages for criminal acts. And that really makes the damage settlements a lot lower, and I think your attorneys are a little less likely to take that on contingency. I think people way overestimate the willingness of attorneys to take cases on contingency and sue. If it's a big case with an insurance company, sure. I had one friend who said, Jimmy, send me your contingency referrals, but he says, please, nothing less than $80,000 and insurance only. So, the smaller cases, even if you've got a pretty good case, it's tricky to get an attorney to handle those. You're probably going to have to pay cash, and that's why I emphasize. We all know that generally, when you sue, 96%. My take position as a transactional attorney that 96% of all your lawsuits filed in Harris County District Court never see the inside of a courtroom. We all know it's going to come down to a settlement, so let's just get with it now and not waste all the time and the money, and we'll have a better settlement for everybody if we do that.
All right, thanks, Jim. We appreciate all the great information. Jim Wiedemer, he's an author of several real estate books. He takes on real estate cases for commercial and residential properties, and brought us some great information today about condo associations, townhouses, and issues that arise with foreclosures and what you can do about them. So we appreciate the great information. If you've got a real estate question, give us a call, 844-788-9444. We'll be right back after a word from our sponsors here on Houston Real Estate Radio.